May it please the Court, my name is curiae and I appear on behalf of the first, second and third amici.
Thank you, Counsel.
May it please the Court, my name is TJ Mahana. I appear for the fourth Amicus curiae.
Thank you, Counsel.
Today, the Constitutional Court hands down judgment in an application by the Electoral Commission for leave to appeal directly to this Court against the decision of the Electoral Court dated 26 April 2024. Following this Court convicting Mr. Zuma of the offence of contempt of court and sentencing him to 15 months imprisonment without the option of a fine, Mr. Zuma started serving his sentence on 8 July 2021. He was released on medical parole on 5 September 2021 by the National Commissioner of Correctional Services. On 21 November 2022, the Supreme Court of Appeal set aside the decision of the National Commissioner of Correctional Services and directed Mr. Zuma to return to the Department of Correctional Services to serve out the remainder of his sentence of imprisonment. Mr. Zuma returned to prison on 11 August 2023. On the same day, President Cyril Ramaphosa granted thousands of prisoners a 12-month remission of sentence in an effort to reduce prison overcrowding. Mr. Zuma benefited from this remission and was released on 11 August 2023. Consequently, he only served about 3 months of his sentence. On 8 March 2024, the MK Party submitted its list of candidates for the National Assembly in the upcoming election to the Commission. Mr. Zuma was included in the list. The Commission received 22 objections to his nomination. On 28 March 2024, the Commission upheld 2 of these objections. It decided that in terms of Section 41E of the Constitution, Mr. Zuma was not qualified to stand as a candidate for the National Assembly. On 2 April 2024, the respondents appealed to the Electoral Court against the decision of the Commission. The Electoral Court upheld the respondents' appeal and set aside the decision of the Commission to uphold the objection. The Electoral Court found that Mr. Zuma was convicted of an offence as contemplated in Section 47(1)(e) as he was convicted of a crime. It held that, and I quote, "The contention that Mr. Zuma was not convicted of an offence is rejected. He disobeyed an order of court which is a crime. He was in contempt of court. The order of the Constitutional Court declared Mr. Zuma to be guilty of a crime," close quotes. Nonetheless, Zondi J.A. concluded that this court sentence is not a sentence of the nature envisaged in Section 47(1)(e), as Mr. Zuma could not appeal against the conviction and sentence. On the legal effect of a remission of sentence, the Electoral Court was split. Zondi J.A. and Yaqub A.J. were of the view that a remission meant that Mr. Zuma's time spent in prison was reduced and did not reduce the effective sentence. Modiba J., Professors Ntlama, Makanya and Puku concurring, found that the remission reduced Mr. Zuma's sentence to 3 months. Therefore, he was not disqualified from being a member of the National Assembly. In this court, the Commission contends that Section 41E of the Constitution disqualifies an individual from being a member of the National Assembly if they have been convicted of an offence and sentenced to more than 12 months imprisonment without the option of a fine. It says that Mr. Zuma was convicted of an offence, contempt of court, and was sentenced to more than 12 months imprisonment without the option of the fine. Therefore, so says the Commission, from the clear language of the section, he is disqualified from being a member of the National Assembly. In respect of remission of sentence, the Commission contends that Section 47(1)(e) is concerned with the sentence imposed rather than the sentence served. As a result, Mr. Zuma's remission did not impact his disqualification under Section 47(1)(e). The Commission argues that where this court, acting as a court of first and last instance, convicts and sentences, the disqualification will come into operation immediately as the conviction and sentence are final and immune from appeal. The respondents contend that the matter is not ripe or urgent, as eligibility to be a member of the National Assembly will be determined at the first sitting of the National Assembly. On the merits, the respondents contend that the sentence contemplated in Section 47(1)(e) is one that is appealable, and that because Mr. Zuma could not appeal against the sentence imposed on him by this court, the sentence is not a sentence for the purpose of Section 41(e). The respondents contend that Mr. Zuma's sentence was reduced to 3 months when the President granted him a remission of sentence, and as such, he is not disqualified under Section 47(1)(e) of the Constitution because his effective sentence was less than 12 months. The respondents also apply for leave to cross-appeal in the event that the main application is upheld. In the cross-appeal, they contend that the Commission did not have the authority to implement Section 47(1)(e) of the Constitution, as this falls under the powers of the National Assembly. Further, the respondents contend that there is a reasonable apprehension that Commissioner Love and/or the Commission was biased. Lastly, they contend that the Electoral Court erred when it found that Mr. Zuma's conviction was a conviction as contemplated in Section 47(1)(e) of the Constitution. They say that if Mr. Zuma's sentence was not one complicated in that section, then the conviction is also not contemplated by Section 47(1)(e). The Council for the Advancement of the South African Constitution, CASAC, was admitted as the first amicus curiae. According to CASAC, a remission of sentence means that an individual completes their sentence at an earlier date and does not retrospectively alter the sentence imposed by a court. CASAC also contends that Mr. Zuma was disqualified under Section 47(1)(e), even though he was not entitled to an appeal, owing to the fact that where this court imposes a conviction and sentence directly for contempt, its decision is final and unappealable, and therefore Mr. Zuma was finally convicted and sentenced. Corruption Watch was admitted as the second amicus curiae. It submits that when this court convicts and sentences an individual, the disqualification from being a member of the National Assembly under Section 47(1)(e) begins immediately. This, they say, accords with the purpose of Section 47(1)(e), which is to ensure that members of the National Assembly are not serious violators of the law. To allow an individual to stand because they cannot appeal against their conviction and sentence would subvert the purpose of the section, submits Corruption Watch. It would also amount to an arbitrary distinction between individuals convicted and sentenced by this court as to those convicted and sentenced by lower courts. The Albert Kathrada Foundation was admitted as the third amicus curiae. It submits that when a person is convicted and sentenced by this court, the disqualification will take effect immediately. Excuse me. It contends that Section 47(1) and Section 19 of the Constitution must be read in harmony, and thus there is nothing constitutionally untenable about the fact that not every adult citizen can stand and hold office. The Black Lawyers Association was admitted as the fourth amicus curiae. It sought to provide assistance to this court on why the recusal application should be granted. It submits that the judges should be recused and that if they are, the doctrine of necessity does not apply, as acting judges could be appointed to hear this matter in terms of Section 175, sub 1 of the Constitution. At the hearing of this matter on 10 May 2024, the court dismissed the application for recusal and indicated that reasons would follow in the main judgment. In a unanimous judgment penned by Theron J., concurred in by Meyer DCJ, Bilchitz AJ, Gamble AJ, Madlanga J, Majid J, Matopo J, Mtlantla J, and Chikri J. This court finds that no case has been made out for the recusal of the named judges because the respondents failed to prove that the judges will be unable to bring an impartial mind to bear on the adjudication of this matter. This court finds that it is not uncommon for judges to interpret and apply their previous decisions. In any event, this matter is about a narrow and defined legal issue that is capable of determination without an interpretation of the contempt judgment. In the main application, this court finds that its constitutional jurisdiction is engaged because Mr. Zuma's eligibility to stand for election turns on the proper interpretation and application of 47(1)(e) of the Constitution. This court finds that it is in the interests of justice to hear this matter because the consequences of the contempt judgment, and in particular the effect of a conviction and sentence on eligibility for the National Assembly, is of public importance. The general public needs to know if candidates on a party list are eligible to be members of the National Assembly. In respect of the merits, this court finds that the purpose of the disqualification in Section 47(1)(e) is aimed at maintaining the integrity of South Africa's democratic regime, which is founded on the rule of law, by ensuring that members of the National Assembly possess the requisite respect for the rule of law. This court finds that the purpose of the proviso is to allow the appeal process to unfold. It is aimed at ensuring that a person is only disqualified from standing for and holding office once their conviction and sentence are final. It does not prevent a sentence that is final and immune from appeal from being a sentence for the purpose of Section 47(1)(e). The reasoning of the Electoral Court in finding that the sentence that was imposed on Mr. Zuma could not be said to be a sentence which the section contemplates cannot be sustained. This is because it has no support in the text of Section 47(1)(e). Section 47(1)(e) applies to anyone who has been sentenced to more than 12 months imprisonment. The text does not qualify the word sentence and sentenced to exclude sentences imposed by this court. The Electoral Court's judgment and the respondent's contentions are tantamount to equating until in Section 47(1)(e) to unless. The interpretation of Section 47(1)(e) of the Constitution adopted by the Electoral Court subverts the purpose to be achieved by the section. In relation to the legal effect of a remission of sentence, this court finds that Section 47(1)(e) focuses on the length of the sentence imposed, not the length of sentence served. The section uses the words convicted of an offence and sentenced. The effect of a remission of sentence is to bring forward a person's date of release. Remission of sentence concerns the execution of the sentence and does not retrospectively alter the sentence imposed by a court. Thus, for purposes of Section 47(1)(e), remission of sentence is irrelevant. In respect of whether the Commission exceeded its powers, this Court considered the relevant provisions of the Electoral Act. Section 30, sub 3 of the Electoral Act requires the Commission to decide the objection, while Section 27 of the Electoral Act deals with a party's list of candidates. Section 27(2)(b) requires that lists must be accompanied by a prescribed declaration from a representative of the party, and I quote, that each candidate on the list is qualified to stand for election in terms of the Constitution, close quotes. The form for a candidate list is prescribed in Appendix 1 to the regulations concerning the submission of lists of candidates, 2004. It requires that a party's list must include an undertaking from a party representative that, and I quote, each candidate on the list is qualified to stand for election in terms of Section 47 of the Constitution, close quotes. The Court finds that in terms of these provisions of the Electoral Act, the Commission is empowered to determine before the election qualification for membership of the National Assembly. In relation to the question of bias on the part of Commissioner Love and or the Commission, the respondents submit that there is a reasonable apprehension of bias on the part of the Commission to the extent that the Commission as a whole was legally excluded from deciding the question of Mr. Zuma's eligibility to stand as a candidate in the elections. They rely on a statement made by Commissioner Love to the media in relation to Mr. Zuma's eligibility to stand as a candidate in the election. Commissioner Love was quoted to have made the following statement on 24 January 2024 at a press briefing when a question was specifically asked about Mr. Zuma's eligibility to stand as a candidate. And this is what she said. That excludes anybody who has been given a sentence that was not subject of any deferral, and in that sense, it is not ourselves, but the laws of the country that would stand as an impediment for that candidacy, close quotes. This Court finds that the Electoral Court correctly found that the context in which Commissioner Love was speaking for the Commission was ambiguous and without specificity. In respect of the question whether Mr. Zuma was convicted as contemplated in Section 47(1), this Court finds that there is no difference between a conviction following criminal proceedings and a conviction following civil contempt of court proceedings, since a person is convicted of a criminal offence in respect of both proceedings. Section 47(1)(e) draws no distinction between convictions for civil contempt and other convictions. Therefore, the ordinary meaning of an offence should be given to the word, that it is a criminal offence. It is not for a court to limit the scope of the provision. The section clearly says, convicted of an offence and sentenced to more than 12 months imprisonment without the option of a fine. Mr. Zuma was convicted in that this court found him guilty of the crime of contempt of court. This court concludes that Mr. Zuma was convicted of an offence and sentenced to more than 12 months imprisonment for the purposes of Section 47(1)(e) of the Constitution, and is accordingly not eligible to be a member of and not qualified to stand for election to the National Assembly until 5 years have elapsed since the completion of his sentence. In the result, the following order is made. The applicant is granted leave to appeal directly to this court. It is declared that Mr. Zuma was convicted of an offence and sentenced to more than 12-month imprisonment for purposes of Section 47(1)(e) of the Constitution, and is accordingly not eligible to be a member of and not qualified to stand for election to the National Assembly until 5 years have elapsed since the completion of his sentence. The order of the Electoral Court is set aside and replaced with the following, and I quote, "The appeal is dismissed," close quotes. The counter-application is dismissed. There is no order as to costs in this court. I hand down the judgment.
Court adjourned.